Good afternoon. My name is Justin Byer, and welcome to today's webinar, Options for Resolving Trade Secret and Non-Compete Disputes, being hosted by Saul Ewing LLP. My name is Justin Byer, a partner in our Chicago office, specializing in trade secret and non-compete counseling and litigation. A bit about me: I represent clients large and small across the United States, helping these clients develop their restrictive covenant and trade confidentiality programs, and helping companies' employees through the onboarding and offboarding process, aiming to help each protect and preserve protectable business interests. I'll be your presenter today. My contact details are available in the Resources tab at the bottom of your screen. Before we begin, just a few notes. Questions. To submit questions, please use the Q&A tool. I'll try my best to answer as many as possible at the end, but we'll follow up by email if necessary. Credit. The program is approved for SHRM and eligible for one distance learning substantive CLE credit in several states. To receive credit, complete the verification survey linked in the Resources tab and enter the numeric codes announced during today's session. Please submit the survey results by Thursday, October 9th. The materials will be provided by email from our team in the coming days with the webinar recording, slides, and credit information. And as you'll see on the next slide as well, we have a fancy disclaimer, which is that these views are not necessarily the views of Saul Ewing. It does not constitute legal advice, and that if you do need legal advice on any of these topics, please contact your attorney to discuss. So without further ado, let's get into the agenda. We're going to start off by talking about the background of trade secret and non-compete law. We're going to talk a bit about using the employment agreement as your first line of defense as a company. We're going to talk about non-litigation dispute resolution. Then we're going to speak briefly on prosecuting a trade secret restrictive covenant TRO case, defending a trade secret restrictive covenant TRO case, and finally, we're going to move into key takeaways. So why is this important? And then we'll give some background here, but a lot of labor and employment law focuses on the means by which companies will need to interact with their employees to make sure that there's not discrimination or other improper items occurring in the workplace. The focus of restrictive covenant and trade secret law is almost flipping that on its head, because it's intended to protect the company from the employee doing wrong, either in the workplace or after they leave, by protecting legitimate business interests of the company. Also, at this time, I want to mention that the first credit code is on the screen. That is 73904. So let's talk a little bit about definitions, legal theory, and confidential information and trade secrets. Restrictive covenant law is effectively what occurs when an employee enters into a contract that restricts some rights of the employee during the employment and after the employment from using information or relationships of the company. But unlike a regular contract, there are certain rules and restrictions that are in place that prohibit every single restriction from being enforceable. Put simply, just because a party signs something doesn't mean it's enforceable. Traditionally, employment or continued employment was sufficient to act as consideration for the agreement, but that started to change. Some states have moved away from this entirely. Some states have modified the means by which a non-compete can be enforceable post-employment. For example, there are low wage restrictions. There are thresholds for high wage earners, and some states have moved to a requirement that there be continued payment during the restricted period. This is important because courts are intended to review and analyze the restrictions to determine whether the company has used a narrowly tailored restriction that serves a legitimate business interest. And we'll talk about that in the coming slides. What this means, practically speaking, is that there are lots of room for your own programs and your competitors' programs to have various footfalls in them. But that leaves a lot of opening for resolving these type of conflicts before litigation is to occur. So I talked a little bit about this idea of the narrowly tailored to protect a legitimate business interest. And what that specifically means is that when we talk about narrowly tailored restrictions, that it has geographic and temporal limitations. Activity restrictions can be substituted for geographic limitations, but the notion is that the court is not going to enforce restrictions that are broader than necessary to protect the legitimate business interests of a company. So what does that mean? Well, traditional legitimate business interests included protecting confidential information, protecting long-standing near permanent customer relationships. Different states are going to have different ways of viewing what constitutes a long-standing near permanent customer relationship. But the easiest way to think about this is that these are not one-off relationships. These are relationships that are built over time, during which companies or their employees are gathering information about the decision makers, about the preferences, about the information necessary to maintain the customer relationship. Put simply, we're talking about relationships that might have sales cycles, might be relationships that have repeat business, it might be relationships that have certain quantities being distributed to the customer at certain times during the course of the year. There are several newer legitimate business interests, and those include maintaining a stable workforce, and that usually is what is the justification for employee non-solicits or no hire agreements, or protecting company goodwill. And traditionally, you're going to see the protecting of company goodwill arise more in the sale of business context. That could also be a sale of partial business. It doesn't have to be the entirety of the business. We talked a little bit about the need for temporal limitations. And what that effectively means is that companies cannot have indefinite restrictions against their employees. That may not necessarily be true of the confidentiality provision, but some states, Wisconsin being the primary one, if there is not a temporal limitation on your confidentiality provision, it's going to undermine the entire enforceability of your restrictive covenant program. I also mentioned the fact that these restrictions need to have either geographic or activity restrictions. The geographic restrictions are a little bit fungible in the way that they're looked at. Many times for sales representatives, it's no broader than the sales territory in which the individual works. However, when you're talking about more of your C-suite employees and to the extent that they have access to information about the company on a more broad scale, those restrictions can be for the scope or the span of where the company does business. So for example, if you're talking about a vice president of marketing who is aware of the marketing strategies for the company, and it's a company that operates throughout North America, they have access to information about the company's marketing plans across North America, then the restriction can be for the entirety of North America. However, for example, that same individual is part of a team, is a VP of marketing, but only has responsibility for the United States, then a restriction that prohibits them from competing in Canada and Mexico would most likely be unenforceable in the court's eyes. An activity restriction is very similar, but it can also prohibit them from holding the same or substantially the same position with a competitor. So for example, that same analogy of the VP of marketing, if they moved over and they were in a VP of sales role, for example, that restriction may not prohibit them or may allow them to take that role. So let's move in and talk a little bit about trade secret and confidential information. When it comes to axioms, I think that all trade secrets are confidential information, but not all confidential information are trade secrets. Trade secrets have a very specific definition, which derives from statute and requires that there be an independent economic value. The information is not generally known or readily ascertainable, and it's subject to reasonable efforts to maintain secrecy. We'll talk a little bit more about what each of those require in the coming slides. Confidential information by its nature is not generally known and subject to reasonable security measures. So typically speaking, you remove the deriving independent economic value. Trade secrets are typically defined by two different statutes. The first is the Uniform Trade Secrets Act. It is an act that has been adopted by 49 out of the 50 states, including the District of Columbia. The one exception is New York, but even in New York's common law approach to trade secrets, it typically follows the precepts of the Uniform Trade Secret Act. The second is the Defense Trade Secrets Act, which is a federal statute that's been in place since 2016. It's fairly similar to the Uniform Defense Trade Secrets Act, but it has a few nuances to it. The first of which is that it requires a whistleblower exemption notice. So, for example, a person is allowed to disclose their trade secrets if in the process of disclosing what they believe to be company bad acts. If that language is not in your agreement currently, it means that you will not have the ability to obtain exemplary damages or attorney's fees if you were to move forward with a Defend Trade Secrets Act piece of legislation. The other nice thing about the Defense Trade Secrets Act is that it does raise a federal question. And so alleging this will allow you to be in federal court versus state court if that is what you decide makes sense from a strategic perspective. And the Defense Trade Secrets Act has some provisions in it which allow the recovery of trade secrets in ways the Uniform Trade Secret Act does not necessarily statutorily permit. While there is a statutory definition of what constitutes a trade secret, and that's set out here in part in the second bullet point, in my experience, if a company is able to articulate the necessary elements of a trade secret, just about anything that is non-public can qualify as a trade secret. So I talked about these particular elements a little bit before, but when breaking down further, what constitutes independent economic value requires a showing that the information has actual or potential value, the value of which is derived from the information not being known to your competitors. So what is an example of that? Well, let's use customer preferences. And let's say, for example, that you are in an industry that has finite number of competitors, and you have worked in a particular market that competitor A has not been in before. Competitor A hires your employee. Through this employee, now former employee, they are able to learn all of the information about business one. Business one now is at threat of being lost to this competitor. And the reason that it's at risk is because now they have access to the customer preferences. Maybe this customer likes to have their products delivered at a specific time and in a specific location in a specific manner. That is not information that is necessarily known to the public at large, as information that has been learned through time and based on the relationship that exists. When weighing whether something is not generally known or not, the question is typically against the industry and not the public at large. While there are lots of things that the public at large may not know, there are less things that are unknown within the industry itself. Moreover, independent discovery or reverse engineering does not constitute or does not violate either of the Defense Trade Secrets Act or the Uniform Trade Secrets Act. And then there must be reasonable efforts to maintain secrecy. And with the advent of AI, what that is starting to undergo some changes. But traditionally, if you have agreements in place protecting this information, prohibiting disclosure of the information, often that, along with other internal information technology security, is usually sufficient to demonstrate reasonable efforts to maintain secrecy. Now, it's worth noting that a smaller company is going to have less of an obligation to have certain security protocols in place than a larger company. And so, if you're talking about a Fortune 50 company, the analysis may require some stricter efforts to maintain that secrecy than, for example, someone who is a much smaller company. So let's talk for a second about the employment agreement and why I view it as the first line of defense. Um, and and frankly, while this particular webinar is focused on ways to avoid litigation and to find means in a non-litigation context to resolve disputes with competitors, the easiest and fastest way to do this is through the use of employment agreements or some sort of restrictive covenant program. These are agreements that don't take a ton of time necessarily to craft, but they do require a level of diligence in having employees sign on to them. And they do require follow-up because the state of the law is changing quite a bit. As a bit of a plug, during our labor and employment executive series later this month, my partner Stephen Kerbaugh and I will be presenting on the changing landscape of non-compete litigation. When conducting this sort of analysis, though, you do want to perform a cost-benefit analysis in determining the length and the scope of the restrictions. I'm going to talk about cost-benefit analysis in greater detail a little bit later when we start talking about both litigation and avoiding litigation. But the reality is that companies should be having internal conversations about what is necessary to protect these legitimate business interests that we talked about. For example, a lot of courts have been conditioned to think 1 year is sufficient and across a host of industries. And so in my experience, courts won't bat an eye at a 1 year restriction. Anything less than 1 year, courts are going to say that's a reasonable restriction without giving it a second thought. When we start to go beyond 1 year, particularly if we start getting to 18 months or 2 years or even longer, those are lengths of restrictions that courts are less familiar with seeing. And in those particular instances, if you're a company that is choosing a longer restriction, then you are going to want to demonstrate why that restriction is necessary. And that could be for a host of reasons. For example, perhaps you are a very specialized company that is working with very hard to acquire customers, and your sales cycle is taking several years to develop. And so every new customer that you bring in the door is going to have taken a very long sales cycle, perhaps a very long private RFQ process in order to land that particular customer. Maybe you're talking about someone who's in the C-suite, and maybe there have been someone who has been responsible for or very tied into the development of a new product or a new product launch or a marketing strategy that has been developed over a series of time and is required substantial effort to develop. If you have the ability to articulate why the length of the restriction is what it is, if and when you get to court, being in a position to do that is going to allow you to demonstrate to the court that you do in fact have a legitimate business interest in the length of the restriction. Same holds true for activity or geographic restraints. Now, for example, lots of times you ask people to sign employment agreements at the outset of employment. And that's tricky because you don't really know how that person is going to progress through your company. Maybe they're hired into, a low-level sales position and then advance in the company to become, an SVP level individual or, maybe, a chief level executive. In those situations, obviously the best practice would be having them enter into new agreements. But sometimes companies aren't nimble enough or do not have that practice in place to do so. In which case you wanted to have your restrictions developed in such a way that allows for advancement in the company and restricts them based on the position they're holding and perhaps, for some period of time prior to acquiring that position. Oftentimes in my agreements, I will work with clients, we'll talk about 24-month look back. So information acquired, positions held, customers worked with in the past 2 years would be ones that would be off limits. The point is to think about these things in advance so that when you're crafting your restrictions, they make sense to your business. and allows your business to grow and the relationship with the employee to grow in such a way as to allow that initial agreement to have viability when the employee eventually leaves the company. You're also going to want to think about state law considerations. You may be a company that is located in, you may be the GC or in-house counsel or HR for a company in a state that has a very friendly view of restrictive covenants, and you may be employing someone in a state that does not have the same view on restrictive covenants. And so sometimes you have to take those into consideration when drafting and when crafting your agreements. And you also need to think, does my program make sense for all levels of employees? If you have people who are not touching confidential information and are not part of the sales cycle, it may not make sense to have them sign an agreement. And also the agreement itself, one size may not fit all for all states. And so that has to be part of the consideration. I'm going to go through this very quickly, but we're going to use some terminology today. If I refer to a restrictive covenant or an employment agreement, it's really referring to the contract that exists between the company and the employee restricting behaviors. Non-competes are referring to a provision in this restrictive covenant or employment agreement that prohibits certain levels of competition during and after employment. Non-solicit is going to refer to either employee or customer prohibitions on asking someone after they leave to go somewhere else to the competitor. No hire, self-explanatory there. And then a couple other ones. Confidentiality agreement is traditionally the way that companies restrict the use, retention, and disclosure of information that is deemed to be confidential. That can include trade secrets. Very often, companies will have a trade secret prohibition as well as a confidentiality prohibition. A lot of other companies define confidential information to also include trade secrets. And then I may be referring to choice of law or venue provisions, in the latter half of this presentation. And that is a contractual provision that sets forth the state in which the litigation would occur or the law that's going to be applied. It is worth noting that if you have been practicing in this space or have been practicing for an extended period of time, the law on this has changed quite a bit. There was a point probably 10 years ago, maybe more than 10 years ago, where almost any agreement with any client that I would work with would have a single state choice of law and venue provision, and anyone working for the company outside of that state would be hailed into that state to defend a litigation. There have been a handful of states that have rejected that and have prohibited out-of-state choice of law and venue provisions. And so you just want to be mindful of that and talk to counsel to figure out or do some independent research to determine where that's prohibited and where that's allowed. So how it all fits together. When you're developing these programs, you want to be thinking about this in weighing the needs of the organization against state law considerations. Does the state in which I'm operating or where my employees work have income thresholds? If we have income thresholds, do we have certain employees who are going to be prohibited from having, let's say, a non-compete agreement because they don't fit the income threshold? Is that sufficient to your organization? Things to have to consider there. You want to factor in and consider recruiting and retention. Prime example, there was a new statute permitted, that went through in Florida earlier this year, which now allows Florida businesses or businesses that employ Florida employees from utilizing a 4-year non-compete. And while that might be advantageous to the company, it may also have significant impacts on the ability of the company to both recruit and retain employees who are being asked to sign these type of restrictions. So you have to weigh those type of considerations. You also need to factor in the fact that these agreements in and of themselves can be seen to restrict competition as opposed to restricting disclosure of information or use of customer relationships. And so you have to weigh the balance in determining how the program comes together. I always think a well-crafted agreement is far cheaper than litigating on one of these cases. And so investing that time and money to enter into one of these agreements, or to come up with one of these agreements, is a better course of action than being in a situation where you have to sue to re-obtain information as it walks out the door. But it is going to require revisions and monitoring for state law changes. I think that the speed at which legislation is passing in various states is far faster than it was when I first started practicing 20 plus years ago. And you're going to see different states do different things. So you have to factor that in when considering your program. Why does the non-compete program work? Well, the reality is that it's in the news, and lots of businesses utilize these. Now, sometimes it's in the news for the wrong reasons. The FTC was on the eve of banning this a little more than a year ago, is when the injunction went in place that prohibited the FTC's ban on non-competes. And so there is some misinformation out there as to whether or not non-competes are viable. But when looking at this from a B2B standpoint, lots of businesses use some sort of restrictive covenant, whether that be a confidentiality agreement, whether that be a non-solicit, whether that be a non-compete. So they are fairly standard. And when companies have these kind of conversations, it is not uncommon to know that another company does have a restrictive covenant program. The other thing about why it works is that if it's well drafted, they are enforceable. And so because it works on both sides of the spectrum, protecting protecting the departing employer's trade secrets, as well as protecting the onboarded or the new company's trade secrets and legitimate business interests, many times companies do want to find a resolution. And let's also be honest, I'm talking to a majority of you who are probably in-house counsel, some of you are HR professionals. The reality is that most companies are risk adverse. And so they want to find a resolution that has definition versus the uncertainty, the cost uncertainty, the time uncertainty, the result uncertainty of a trade secret or non-compete litigation. So let's move into the non-litigation dispute resolution meat and potatoes of this presentation. So I believe that this process really starts with the onboarding process. And in the onboarding process, you have to be approaching this from a bit of a defense mindset. You want to be proceeding with your eyes wide open. And so what that means is you need to know what obligations this potential new employee owes to the competing organization. You want to be asking for any agreements that they signed with their prior employer, whether you're calling that an employment agreement or restricted covenant, stock option agreement. There are a number of places where these type of restrictions can be included. I think it's really important to be prepared to have honest conversations with the business if they are gung-ho on hiring someone as to whether or not they can continue to work with their prior clients. Now, you may look at the former employer and say, we're not competitors. But if the former employer is going to make the argument that you're competitors or that maybe you're competitor adjacent. So for example, let's say you're a supplier to the former employer, and their concern is that if you go out and hire this person, maybe you're going to find business that is going to replace them. And so they have a concern about you going out and being in a position where maybe you're not a direct competitor, but maybe you're kind of in that gray area of competition. So some of it is about having honest conversations about what you really think the former employer is going to think. Sometimes those conversations can also be after you've onboarded the person to ask the honest question about, what typically happens with this former employer's employees. So, for example, if there's lots of these employees who are leaving and going to other businesses in the industry that are in the same segment as you, that may be a fairly good sign that they are not going to prosecute that particular, employee's departure. On the other hand, if you have hired a half dozen of those same of that same company's employees over the last several months, you may be in a situation where that is the straw that broke the camel's back, and it may result in a cease and desist letter or threats of litigation. And so some of it is about weighing the pros and cons of the hire. It's really important that if you're in a situation where you think that there's a possibility of competition, about figuring out ways that you can silo the new employee in a way that allows them to come on board, but is not going to put the prior employer's information or customers at risk. This is really common in the sales context, for example, but if you've got someone who's in the sales force coming on board and you can prohibit them from soliciting or doing business for a set amount of time with any of their former clients, you can usually put the former employer at ease and create some sort of meaningful pre-suit restrictions that allow this to happen. I also think it's really important for in the onboarding process to set clear expectations in the offer letter. For example, don't hide the fact that they turned over their agreement. I would say out front, you provided us with this agreement. You have represented to us that this employment is not going to cause you to breach any of your restrictive covenants. We have made clear to you that we are not interested in any confidential or trade secret information you've acquired from any third parties, including your prior employer, and that if you disclose any of this, that will be grounds for discipline up to and including termination. Usually putting that language in, it can have a twofold effect. One, you're able to put that employment or that offer letter in front of the former employer to demonstrate, listen, we're hiring them for their general skills and knowledge. We have no intent of allowing them to breach the restrictive covenants here, particularly the non-solicit and the confidentiality provisions. The second is if you do end up in the litigation, you can put that in front of the court as Exhibit A as to why this is not tortious interference, especially if you are putting your money where your words are in your offer letter and monitoring and can demonstrate that you're monitoring their efforts. Protecting yourself, though, is not just about the onboarding process, it's also about the offboarding process. And some of that can be done through your exit interview. And if you don't have an exit interview, then you should strongly consider instituting that as a policy. And I'm not saying that just because this is a situation where you want to have this in place if and when you have an employee depart for a competitor. The reality is that you can find a lot of information and you can do a lot of your sort of pre-dispute checks in this type of interview. For example, in the interview, you can provide them a copy of any restrictive covenants they have in place to the extent they don't have that, ahead of time. You can ask them questions about where they're going to work. You can remind them that any information in their possession that they obtained from the company does not belong to them. It needs to be returned. If you document that, that is information that you can then turn around and use if you do end up in litigation to demonstrate we reminded them, they told us they didn't have anything. They in fact took a bunch of stuff. In the exit interview, you can usually request certain types of disclosures. So for example, if they used a firm computer, you can request that they turn that over in its current state without wiping it, provide you any access credentials necessary. If they used a personal device to conduct business through, perhaps an email server on their cell phone or a VPN network on their home computer, you can oftentimes get into those devices to wipe any of those materials on the front end. And those are going to demonstrate and a lot of times protect you against that information walking out the door. It's really important to note that when an employee gives you notice, or if an employee does not give you notice, it is not the time to sit on your laurels. And the last thing I'll say here is you don't ever want to hope for litigation, but I can't tell you the number of litigations that have been short-circuited because the company repurposes the computer or wipes the physical device. I recognize that companies nowadays utilize a lot of cloud-based repositories for storage of information. But when you're conducting a forensic investigation, it's almost as though the fingerprints themselves are on the device. And if you wipe the device or you repurpose the device, you're going to lose all those fingerprints. And so oftentimes when you end up in litigation in a trade secret or non-compete context, a lot of that information tends to be, a lot of the allegations tend to be developed circumstantially. And so having the device in your fingertips is going to allow you, for example, to be able to demonstrate this employee had a personal cloud repository on the device. They accessed that personal repository hours before they, they gave their notice. While they had that open on their screen, they also accessed, these scores of documents on their computer that we're able to show because the timestamps on the documents and various metadata associated with it. If, however, that gets wiped, then all of that locally stored information is gone. And that becomes very difficult to recreate on the back end, irrespective of the cloud based storage programs and protocols you have in place. So when you are confronted with this type of dispute in a pre-litigation context, you have to start thinking strategy right away. I think the normal reaction for a lot of businesses is to say, we need to send a message, or we need to fight this, or it's a little bit of the scorned lover syndrome of this person left for a competitor and now we want to hurt them. But really, that needs to be the time where you take a step back and really start thinking about what does a win look like for our organization? Is it maintaining a customer relationship with these five particular companies? Maybe they're at risk. Maybe they're they're going out to bid in the next like several weeks or several months. Is it ensuring that your information has not walked out the door? Is it that you have a very specific product that you're about to launch and this person was really involved in it and you don't want them anywhere near similar products for some period of time, or siloed from that type of thing? Having those conversations internally and honestly oftentimes is mission critical to avoiding litigation, because then you can say to yourself, this is what we see as the victory in this case. And if that is puts you in a position to say, we are 95% there, you may have to weigh the fact of, is the extra 5% that is available through litigation worth filing that case? Because you're again conducting a business or a cost benefit analysis. You have to think about the actual cost of litigation. You have to think of the time cost to the business. Litigation isn't filed in a bubble. Once you get into discovery, it has a very significant impact on the business when it comes to the hours that they're spending dedicating to a litigation. And again, I kind of talked about it at the beginning of this slide, but you're really asking yourself the question, what really is at stake for your business? Now, sometimes litigation really is the only, way to move forward, because someone walked out the door, they took a customer, that customer is worth, millions of dollars in business, and now you have to try to recover that business. But developing strategy before starting a fight or getting into a fight is really important, because it allows you to weigh what is of value to your company and how do you best align your pre-suit goals with that outcome. I think it's also really important to weigh some of the legal questions at that outset. And these are items that you would have to consider if you filed for litigation. But it allows you to really, again, kind of weigh that cost benefit analysis to filing suit. So asking the question, are we actually competitors? Now, if you're the onboarding company, you may say, of course, we're not competitors. But if you're the GC of the departing company or HR for the departing company, you may think we are absolutely competitors. So sometimes there's going to be a difference of opinion. And so asking those questions or asking where maybe there is an overlap can also allow you to think flexibly about a solution. You also want to weigh what the risk of harm is. Again, I mentioned this before, but are we talking about prohibiting them from soliciting former customers? Are we requiring them to sell a different product? Are we looking for them to be siloed in the organization so there isn't a touch point that overlaps with what they are doing? Is this a diversified business where they're being hired into a different business, but one of the subsidiary companies does the same thing? I mean, are you just looking for assurances they won't do any work for this company? There's a lot of different ways that you can get to the point where you're going to be comfortable with losing that employee or bringing that employee on. But some of it has to be thinking about things in a broader standpoint. You may also want to be looking at and considering, are these restrictions narrowly tailored? If they are facially overbroad, that may put you in a position very quickly to find a resolution. Now, unfortunately, my experience is there are a lot of people who practice in this space who do not necessarily have a broad-based knowledge and understanding of trade secret and non-compete law. And so there are unfortunately some both in-house counsel and outside counsel that effectively view an agreement, if signed, as being enforceable. Obviously, we've talked a bit before about what the court should be weighing, but I'll tell you that there's handfuls of examples where the courts also say, if you sign something, we're going to enforce it. So while I think it's important to have that conversation, really at the end of the day, the more important question to you has to be or should be, can we live with what is going to potentially be the workaround solution? When it comes to the trade secret side of things, again, are we talking about real trade secret information? Is there actual misappropriation? Was it innocent retention? Can you solve some of these things by either returning or having the information returned? You know, did you or the former organization take adequate steps to protect the information? Now, I'm not saying you shouldn't try to reobtain the information, even if you didn't take adequate steps. But let's say, for example, that you don't have a non-compete program, you don't have a confidentiality program, and you're accusing someone of taking information. That may not be the case that you want to take to court. And so that may be a case that you want to strongly consider, can we use out of court steps in order to regain this information? So let's talk a little bit about some of the options. Well, the classic one is the letter writing campaign. Reminder letter, demand letter. I think it's important to put identifiable benchmarks in place that allow for resolution. So instead of saying the other employer or the new employee has 7 days to no longer work at this company, that's usually not going to create a solution-oriented approach to things. But it may be provide us assurances that you're not going to be soliciting any of your former clients. Provide us assurances that you don't have any information in your possession. Be willing to have a conversation about restrictions on customers or employees that you're restricted from soliciting or having any work with over the course of your restrictive covenant period. If the expectation is 100% of what your restrictive covenant gives you, it makes it very hard to resolve things. And so you have to think about this from a business negotiation standpoint. And so this is where we start talking about some of the non-litigation settlements with the new employer. There are any number of ways that you can do this, and some of it is, again, coming up with an express list that they're going to be kept away from. Creating a certification program where they're going to have to certify in writing they haven't done these things. Now, Is that a perfect solution? Not always, but it gives you the peace of mind typically to resolve these things. And then if you find out that they breached it, then you have recourse to go after them for this. But it doesn't mean you have to necessarily go and seek court intervention to obtain that right off the bat. Some other things that exist, there can be forensic investigation and remediation. If you believe and if you have evidence that someone retained information, there are a host of ways that you can get to a point where you can demonstrate or verify forensic remediation and wiping of the information off those devices. It happens a lot. It happens in cases that I work on. It can oftentimes be the most expeditious and expedient way to recoup that information and prohibit it from going elsewhere. And frequently, what you'll end up having is an agreement to sideline that person for the limited amount of time it's necessary to wipe those devices. Oftentimes, if you're in an agreement that this is going to take place, that is something that can be negotiated as well. And then there's always mediation. We certainly work with mediators frequently in a pre-litigation context, which allows us to avoid a lot of the costs and get to a resolution quickly. Let's take a little bit of time to talk about prosecuting a trade secret and non-compete action. Typically, you're going to run into three traditional causes of action: the breach of non-compete or breach of the restrictive covenant agreement, trade secret misappropriation, or tortious interference. I'm not going to spend a ton of time, delving into, the specific questions that are raised here. We've talked about a lot of these, but these are some of the things that you want to be analyzing as you get into a point where you're going to be enforcing a restrictive covenant. It's also really important at the outset to have your evidence collection protocols in place. That should include a well-maintained employee personnel file. That is usually the place we're going to find the actual restrictive covenant agreements, or if they have agreements through some sort of stock option program. It's going to oftentimes include employee reviews, which are frequently a very good place to identify their actual day-to-day job responsibilities. It's usually a good place to demonstrate that this is a valuable employee who's leaving and is not someone we're going to lose lightly. Oftentimes you have information about compensation that they're making, bonus awards for states that have an income threshold. That's a really good place to find that information. As a litigator, it's the very first thing I ask in-house counsel for HR personnel. If time permits, I often suggest having a forensic examination. And it's important to image the device, because when you start manipulating documents in the back end, it changes some of the metadata, particularly the last access dates. And once you access it again, it then changes that information, and it does not allow us to see really the information as it would have last been touched by the employee. So imaging the device, it's not a particularly expensive thing to do anymore. And doing a quick triage of the device to figure out information there is important to prosecuting it. And then you want to be prepared to know, like, have we been impacted? Almost every single trade secret action that I've ever filed, non-compete action, is supported by an affidavit. And that's usually by a custodian of record and a business person. It might be other people as well, but those are typically the two people we're going to need access to. And so if you're preparing for this type of litigation, you're going to want to be in a position where you have those people readily available to answer those questions quickly. Moving to the defending trade secret non-compete action. This is really the quintessential fire drill. And frequently these type of litigations are filed with the intent of gaining strategic advantage over the hiring employer, and getting into court as quickly as possible to effectively catch them with their pants down. And graphic rhetoric aside, these cases get filed at inopportune times because you, as the prosecuting party, want to get in front of the court with your side of the story told as fulsome as possible and not allowing someone else to respond. And the reality is that when you're the defending company, you're going to be quickly responding to this. You oftentimes don't have advance warning. You are often going to be required to answer or move to dismiss at the very same time that you're responding in opposition to the motion for TRO. So there's a lot of legwork that needs to be done there. These responses also need to be submitted or supported by affidavit to either respond to or counteract the information that's being provided. It may be in a jurisdiction where you don't traditionally have lawsuits, so you may be looking to line up local counsel. You may be doing a quick and dirty forensic analysis because, let's say, for example, the other side alleges that there were 5 external USB devices plugged into that computer, and they identify it with serial numbers and makes and models. You may be forensically imaging that that new employee's device to say none of these were plugged in. And it's definitely going to involve very substantive interviews of not only the employee who's being onboarded, but probably also people involved in the hiring process and maybe even the supervisor of the new employee. And we're going to ask a lot of the same questions that we were talking about before. Questions about, are the restrictions narrowly tailored? Are there actual trade secrets at risk? A lot of that comes down to the question of, are you competitors in the business place? So even if the employee walked out the door with a host of different documents that they shouldn't have, but you're not actually competitors, that information is not at risk. Doesn't mean he or she should have taken the information, but it also doesn't necessitate necessarily a temporary restraining order. You want to do opposition research, knowing the judge, knowing opposing counsel. Do they prosecute these cases? A lot of times you can tell from what's in the documents themselves. Sometimes you can tell from their bios on their websites. But the reality is that knowing that information is going to help you, the client, and whomever you retain as outside counsel to help you in that type of case in developing strategy on how you want to proceed. And you also are going to unfortunately have to make the decision of whether or not you think personal jurisdiction exists. Because if you go into that case and you don't challenge personal jurisdiction and the court enters an order essentially finding personal jurisdiction exists, then you're going to unfortunately have waived that personal jurisdiction. So something you have to keep in mind. So let's move into some key takeaways before we open it up for a little bit of Q&A. When developing your own program, it's really important to realize that the days of the one-size-fits-all model are probably over. You have to design your restrictive covenant program to deal with today, but also tomorrow. So you don't want to so narrowly tailor your program to restrict competition against, let's say, 5 competitors. And 10 years from now, when you're enforcing that agreement, you've now got 15, 20, 30 competitors in the industry, and you can't stop them from going there. As an in-house counsel, it may be hard to do this, but you do want to keep in mind that there are frequently changes in the law, particularly if you're in the healthcare space. That's an area that seems to be having changes to laws on a almost yearly basis at this point. You want your programs to be nimble. I frequently have or frequently draft for clients almost 50 state agreements these days. So they have the restrictions and they might have carve-outs in the agreements, allowing us to utilize these for our nationwide workforce, while also allowing us to make modifications to an addendum versus having to change 50 different agreements at its given time. And I think it's important to find a trusted advisor, whether that is someone internally who does this type of thing, or if it's outside counsel to help stay abreast of what is going on. And very important, don't try to enforce unenforceable restrictions. It's the quickest way to lose credibility. It's the quickest way to end up in Law 360 in a way you don't want to be. I also want to take a moment and say that the second credit code for today is at the bottom of the screen. It is 82156. Again, that's 82156. We focused on this a lot more today. The takeaways for hiring. Don't assume just because an agreement is in place that's enforceable. Do pay attention to choice of law and venue provisions and evaluating enforceability. Do your absolute best to wear the white hat. If there's someone who is just not possible to hire because of the way the restrictions are worded, move on to the next candidate, even if they're the perfect candidate. Because the last thing you want to do is go into court looking like you did something that violated things. My experience is judges really don't like people who look like they've done something wrong. And that's the quickest way to get yourself in trouble in a litigation context. Do make clear the expectations in the offer letter and in your own agreements, and really make sure to follow up with competitive hires and their management. Just because it's in the offer letter saying they won't do it doesn't mean that it's not going to happen. And so there needs to be periodic check-ins to make sure that they're actually abiding by the restrictions that are in place. And when there's the possibility of litigation, you know, just remember it's not the only option. There are ways to approach dispute resolution, which allow you to either hire the employee or have comfort that in the departing employee leaving that will leave you in a position to be able to move forward without the expense of litigation. Um, Remember, the new employer probably wants to avoid litigation as well. And very important that if you're the one who's losing an employee, trust but verify. You can trust them, their word, but find ways to verify that um, they're in fact abiding by their restrictions. And then if you are litigating, make sure you're collecting your facts quickly, retain evidence. That includes text messages, it includes metadata. You do not want to be in a position where, unfortunately, you are putting your defense or your prosecution at risk because you have not retained the text messages of a key employee. And remember, assess your weak points like right from the outset, because that's the best way to understand what a win looks like. If facing litigation, you want to triage this. Quickly develop facts, quickly develop strategy, quickly, analyze your claims. You're going to want to determine if you're representing the new employee or not. You're going to want to use your onboarding program to fight these claims, particularly when it comes to misappropriation, particularly when it comes to tortious interference. If I'm prosecuting these cases, I want the new employer to be as liable as the former employee, because the far more likely scenario is that the new employer is going to be in a position to be able to afford the damages that the former employee subjected. So if you isolate yourself because of the way that you have onboarded this person, you're in far better shape than otherwise. So I do see a couple questions in the chat. One of those relates to the first code that was provided, and we'll provide that to that individual offline. The second question was question about antitrust considerations to non-solicitations, no hire provisions. And it's a good question, and it's a little bit out of the bounds of this discussion. But traditionally, the antitrust piece comes into play when companies are making business to business agreements not to hire or not to solicit each other's employees. It does not typically unfold in a situation in which a former employee has an agreement in place that restricts them from identifying or not soliciting a former customer or a former employee. So, for example, this type of agreement may be John Doe for 1 year is prohibited from hiring or being involved in the hiring process, or sorry, soliciting or being involved in the hiring process of such and such people from your company. It does not prohibit the new employer from hiring these people. It just prohibits the other person from doing so as well. I do see a couple other questions about the CLE codes. We will get that to you offline. If for some reason you missed it because it was as upfront as it was, just reach out to us and we'll get that to you. We have now reached the top of the hour, and I will appreciate the fact that this is an hour-long program. But thank you so much for attending. If you do have other questions or follow-up, please feel free to contact me. My contact information is here. I'd love to be a resource to you and your company on these type of programs and these type of litigation type matters. So thank you again for your attendance and have a great day.